Good morning, everyone, and thank you for joining us on our webinar this morning, the Modernization of Estates Law. So thank you all for joining. We have a great speaker today, which is going to give us so much information. So I'm really excited for today. I am Stephanie Giorgio. I am your events manager with MBOT. So thank you again for joining us. We are recording today's call, so it will be available on our site in the coming days. So you can definitely refer back to it on our site. It'll be under MBOT News. And just a few housekeeping rules. So we will be taking a few questions today. So if I can ask you just to put your questions in the chat box, and Daniela will get to those at the end of our presentation. We'll save some time. You can even unmute yourself during the Q&A if you want to ask a question live, where Daniela is more than happy to take those live as well. So in that, I will introduce Daniela. So Daniela Fonseca is an associate at Kaiser Mason Ball Law and a member of the firm's business and estate succession practice group, where she works as both a solicitor. Daniela assists individuals, both those with and without businesses, with their estate planning needs, including drafting of general and limited wills and powers of attorney and various trust documents. Daniela regularly advises and assists estate trustees with navigating the estate administration process when an individual passes away, including the probating of wills and the winding up of estates. So I welcome Daniela, and I will pass it over to you.
Great, thanks, Stephanie. Good morning, everyone. Can you hear me okay, Stephanie?
Yep, everything sounds perfect.
Okay, great. So yeah, thank you to MBOT for inviting me to speak today. I am going to be talking about some changes and really updates that that have occurred over the last couple of years, or well, over the last year, I should say. Some of these changes were needed to modernize the estates practice or bar, and then and some are needed for it arose because of the pandemic and the need to really to help people that, you know, when we were in the stay-at-home stage, lockdown stage, so to speak. These changes came about as a result of the government enacting what's called the Accelerating Access to Justice Act in 2021. And they make changes to our Ontario inheritance law, so what is called the Succession Law Reform Act. And I'm going to be referring to it as the SLRA for short. So one of the changes that came about as a result of the pandemic was the ability to remotely sign wills and powers of attorney. So initially this was brought about as a temporary measure, but it has now become a permanent fixture of the SLRA. So the virtual execution of wills and powers of attorney can now, under Section 4, subsection 3 of the SLRA, we now are able to sign wills and powers of attorney using audio-visual communication technology. Now, this must be done, it still requires the presence of two witnesses on the video side. So we need two witnesses, the person signing the will, the testator, or the power of attorney, the grantor of the power of attorney. At least one of those witnesses, though, does need to be a licensee of the Law Society of Ontario. So it must be a lawyer or a paralegal. The other witness does not have to be, so it can be the lawyer's assistant or paralegal's assistant. So that was a big change, and really one of the, you know, it is a good thing to, you know, for certain individuals who are still not able to, you know, come to the office. You know, it allowed, especially for those that were very ill or, you know, immunocompromised, and even going forward, this is a great change. So just moving on to the next change, another big change that came about as a result of, and this was not in particular was not a result of the pandemic in particular, but it was, I think, time, and the government realized that that it was time to modernize this portion. But marriage will no longer revoke a will. So this, and I'll refer to particular sections. I know you guys don't have it in front of you, but sections 15 and 16 of the SLRA were repealed as of January 1st, 2022. So those were the particular sections that dealt with marriage and how the legal effect that they had on a will. So prior to this change, a marriage after the execution of a will, so let's say someone signs their will and 2 weeks later they got married. That marriage, the day they got married, essentially they don't have to do anything. The will is their will that they signed 2 weeks ago was automatically revoked. So it's as if they have no will. So this, it could have been problematic, and it was for many people. This is no longer the case. Okay, so now a marriage will not have any legal effect on a will. And prior to as well, it would have, this change was a little bit, we had to be careful when dealing with, for example, common law couples who, let's say they weren't in a rush to get married, but it may have been on the table at some point down the line. We would have to ensure, as the lawyer, we needed to ensure that we included a specific clause called making it in contemplation of a marriage. So if we did not include this clause and the common law couple, let's say they made their wills, 3 years later, they completely forgot, that about, they don't pay any attention and they get married and they forget about the wills and they don't realize that their marriage has revoked those wills. So that could have been a big problem, right? So that is no longer the case. We no longer have to make wills in contemplation of marriage if we're dealing with common law couples. So while the change is a positive step, and it's actually good, I believe, it would help protect against what we call predatory marriages, or let's say, individuals that might target a vulnerable person that has money, right? Just by way of example, it would help protect those vulnerable individuals. It still comes with its own challenges. So, of course, if someone is single, makes a will, but then gets married or, remarries, enters into a second marriage, it's still important to consult with a lawyer and make sure that your documents are up to date and make sure that, you've got, because you might, it's very likely that you'll want to include your new spouse or, you'll probably want to make some change to reflect your new life together. So that's a big change that came about as of this year. The next big change that also came about as of January 1st, 2022 is that the inheritance law in Ontario has been amended to treat separated spouses, so ones that are not divorced, but they will be treated as divorced spouses. So essentially, separated spouses will not receive any benefit from the estate of the deceased. And the particular section of the SLRA that dealt with that is section 17. So that has been amended because before this change, separated spouses were still treated as legally married spouses. So essentially, there was no differentiation. So if somebody had been separated from a spouse for 20 years, they just never got around to getting divorced. And then that person is now in a new relationship with somebody else, they have a completely new life, but that person passes away. The separated spouse could very well, unless there was a document, a separation agreement or something, excluding, any rights that separated spouse has, they would be entitled to claim against the estate of that deceased just because they're not divorced. Whereas a divorced spouse would not have that same entitlement. A divorced spouse would have been treated as if they had predeceased the testator in a will, or they would not be able to take advantage under the intestacy rules. Intestacy means if someone dies without a will. So, so Section 17 has been amended to treat a separated spouse as if they are a divorced spouse. So this means that both separated and divorced spouses will no longer receive any benefit under a will. If they are named as an executor, they will not be able to act as an executor. It will go to the next person who's named in the will as an alternate, or it will be, someone who's more appropriate to apply for that role. And the benefits that they would have received under the will are revoked. If we're dealing with a situation where there is no will, then Section 43 of the SLRA will take care of that. So it provides, it's a new section that's been enacted. So it provides that the separated spouse will not receive what they would have, what we call a preferential share. So the preferential share, you can think of it as kind of first dibs on the estate. So the first 350,000 of the estate would have, and there were some, that was another change in itself. So prior to March 1st, 2021, it used to be for deaths that occurred before that time, the preferential share would have been the first $200,000 of the estate. After March 1st, 2021, it is now the first 350,000. So that is the preferential share. So if a spouse, you have a couple, wife dies, husband survives, they're legally married, but there's no will, and they were not separated, the husband will be entitled to the first $350,000 of the wife's estate. But if that couple had been separated, the husband separated or divorced, the husband does not have a right to that preferential share, and will not be entitled really to any benefit. So yeah, this is another big change, because for years it complicated, there was always the intersection. We had to make sure that we carefully coordinated with family law practitioners to make sure that we were protecting individuals from these conflicts that could arise and really end up in prolonged legal battles once after someone died. So this is a very big change for our practice. The next major shift or change, I should say, is when it comes to the validity of testamentary documents. So again, as of this year, January 1st, 2022, Ontario will shift or has shifted from a strict compliance regime or approach to validity of documents to a substantial, what we call a substantial compliance approach. So essentially it means that, so a will under the SLRA prior to January 1st, a will had to have, it was very strict requirements. It needed to either be a typed document, it needs to be signed at its end with 2 witnesses, or it can be a holographic will, so something in writing. I mean, we don't recommend that you handwrite a will. That is a whole other set of challenges. It goes kind of beyond the scope of what I'm talking about today. But in any case, under the SLRA, a holographic will would be considered valid. It's just completely in the testator's handwriting. Now, for as of this year, 2022, the courts, if on an application, so someone actually has to apply to the court and go before a judge with their position and evidence, but it could set out, you could bring a document that sets out testamentary intentions and potentially have that validated as a will. So it might very well be a will that was typed, but it was not signed. And let's say, unfortunately, the individual, they were going to sign it, they had an appointment to meet with their lawyer the following week, and they died, unfortunately. So the executors who were named in that unsigned document could very well go to the court and say this person was going to sign their will, but they unfortunately passed away before they got a chance. And the court has the ability, they have the flexibility to say, based of course on the evidence, it's always going to be on a case-by-case basis, but they can say, yes, then, we agree, this is a valid will, even though it's not signed, it's not witnessed. Or, it doesn't have to be, that's just one example. Because it's so new, we don't know how it's going to play out necessarily in the courts, but that is one example that we could see being, pretty a common thing, because it has happened. It happens. Another example, and this again, it remains to be seen how it will be, play out in the courts, but there may be a preliminary document setting out intentions. For example, a questionnaire that we often in our practice will send out questionnaires with information, questions that we need the client to answer to that we will then use to discuss with them, confirm their instructions, and prepare their documents. So it may very well be that the only document that they have indicating someone's intentions is this questionnaire, and that could potentially be put forward to the courts or to a judge to say this is a valid, it's a valid testamentary document. Again, this change is so new that it remains to be seen how it's going to play out in the courts, but that is an example that I could see happening. Another change that came about in the last year is changes to the probate process. So just a little bit of background. Probate is the process of getting the original will approved as the valid last will and testament of the deceased person. So it's a confirmation from the court that there is no other will floating around, that nobody has been improperly excluded. So there are situations where, a will may be declared invalid because they, completely excluded a fully dependent child or something. That is one situation. There's so many other examples, but, those dependent children or people may have legitimate claims to the estate. So the court could potentially find that will invalid for that reason. That's an example. But essentially, it's the process submitting the original will to the court, getting it approved as a valid last will and testament. There's nobody, confirmation that there's nobody challenging anything, and that and it confirms the authority of the estate trustee to act. It's a authority that a lot of banks, third parties will rely on. So commonly, it's a bank that will request this authorization from the court, so that they can satisfy themselves from a risk perspective that they're not going to have any problems with this estate and when acting on instructions from the executor. So prior to that, all estates, whether they were large or small, were treated the same. So prior to April 1st, 2021, which is when the new change that I'm going to talk about came about. So prior to April 1st, 2021, all estates, whether they were $6 million or $20,000, were treated the same, and the executors for those estates would have to apply to the court using one specific set of documents and follow a certain set of rules. Now, after April 1st, 2021, we have a route specifically for small estates. And small estates are those valued under $150,000. And the hope, or the idea is that because there were certain estates or small estates and individuals that they were concerned about the length of time, the cost, just the stress of dealing with courts, who, to be quite honest, can be very backlogged, especially when in certain cities and certain jurisdictions. It was just not worth the hassle for certain estates under a certain amount. So now with the small estate route, the idea being that it's going to be a lot more streamlined, and it's a lot faster. It's a lot basically it takes away the time in the backlog. That was the concern, the backlog and the cost as well. So the small estates procedure, it allows an executor, they make an application it's a little more condensed. So, you know, we still have the traditional route for estates, which we have to use for larger estates, of course. But, you know, if someone comes to us now and they say, you know, we have this one asset, it's a bank account of, you know, there's only $50,000 in it. Bank is still asking me to get probate. We can use this, we can apply using the small estate route. You know, it still involves preparation of documents, but it's a lot quicker and you know, again, it's quite new, so it remains to be seen if it really will, you know, streamline the process. I believe it will, but you know, there's certain challenges. Again, kind of goes beyond the scope of what I'm talking about today. But yes, the principle is that it is a more streamlined route to allow faster executors per small estates to get these certificates faster, to get this authorization faster, to be able to deal with the estate quicker, a small estate. So essentially, it's you know, there's, you know, now the hope is that, you know, someone who wouldn't have bothered deal with that $50,000 account now they can quickly get their certificate and close up what they need to wind up the estate, and we're not just leaving this money floating around with no one to really benefit from. So yeah, so just to kind of go into the specifics of it. So the small estate application, it still requires, you know, a proof of death. It still requires, if there is a will, an original will, it still requires proof. So we typically with wills, we'll have something called an affidavit of execution, which is signed by one of the witnesses to confirm that they saw the testator actually sign their document. So it still requires that. It still requires that anybody who's entitled to be notified. So any beneficiaries, either if there is a will, and I should note, you know, the estates rule, it can apply to even if there is no will. So it's not just for wills, it also applies to those who pass away without a will, but, you know, that person, again, as long as their assets, the estate, what they owned at the date of their death was valued at $150,000 or less, they can use this route. So it still requires, you know, presentation of certain documents, and that beneficiaries be served with a copy of the application and then the notice, basically that saying the executor is applying to be appointed as such. It is a more condensed application, so the actual documents compared to the ordinary procedure. Now, it's a little bit different in this that, so going the ordinary route, you don't actually have to list in the certificate that you get from the court, you don't actually list the assets of the executor, or sorry, of the deceased person in the certificate of appointment. In a small estates, going the small estate route, you do have to. So this is the tricky part, because you will need to make sure, or the executor who's going to be administering the estate has to be sure that the assets that they're going to be administering, or that they're aware, that they are 100% aware of the assets that form part of the estate. Because if not, because they have to list it on the certificate that will be issued to them once everything is approved. But if they're not, and they later discover that there is an asset worth another 100,000, 200,000, whatever the amount is, and it goes over that 150,000, they will have to then make another application using the ordinary route, because now we've got an estate that you're limited, you have a certificate that was issued, and it only has the one asset listed. So you're only actually, under a small estate route, you're only able to administer the certificate that is, or the asset that is listed on the certificate. So if you've got another asset that's outstanding that wasn't included in that certificate, you're going to need to get approval to then administer that. So that's kind of one of the drawbacks of the small estate route, is that you really, really have to be familiar with the deceased assets. So yeah, there, you know, it is a benefit. It is, you know, it's definitely a welcome change, because, you know, as I've mentioned, certain courts and certain probate can be notoriously backlogged, and it can take many, many, many months. I've seen it take upwards of a year in certain areas to get that, you know, confirmation from the court that that is the valid last will and testament of the deceased person, or confirmation that they have that authority to act. And obviously it comes with its own set of challenges, because, you know, you're waiting this long. And in the meantime, things need to be taken care of on behalf of the estate, right? So you still need to, bills still need to be paid if we've got a house, and you know, or property, or if we've got, you know, there's things that need to be taken care of during that time. So, you know, having the option to go this route, if you don't have anything, it really helps open up and improves access to justice, in the sense that, you know, it oftentimes, I mean, I can only speak for our firm. I don't know if the practice will be the same out there, but the hope is that because it's a more condensed type of application, it won't take as long. There's not as work intensive as other estates can be. And so it attracts lower fees. It would result in lower costs to the client. So that is also the hope in trying to improve that access to justice that is often discussed. And, you know, magically we don't know if it's really working just yet, but yeah, that's the hope anyway, that we can do our part to improve that access to people that otherwise would just leave an estate and not really, and they could very well benefit from the money, you know. So those are the key changes that I wanted to speak about, as these are the major, you know, there hasn't been updates like this in many, many years. So it's definitely welcome to see, and it's going to be tricky for us to navigate in certain situations, especially with the separated spouses, and that's going to be tricky, because that just the fact the data separation can be such a contentious in itself, you know, agreeing on, okay, were these people actually separated or not? That is certainly going to result in some court battles. For sure we're going to see that. So yeah, that's pretty well what I wanted to speak about. And I'm happy to open up the floor for questions.
Great, thank you so much. As I mentioned earlier, you can either unmute yourself and ask your question. We have no issues with that, or you can put everything into the chat box. We are open to either one, so we can start doing that right now. Does anybody want to unmute themselves and ask a question? We can start that way. Or Andrew, I see that you unmuted yourself. Go ahead.
Hi, Daniela. Thanks so much for that presentation. That was fantastic. Just wanted to let you know that with respect to the small estate, I was recently appointed by the court as a trustee on a small estate. And to give you a sense of the time frame, I applied in October, and the estate was approved by the courts in late February. So I don't know if that's fast or slow.
Ooh, which court was this?
In Milton.
In Milton. Yeah, to be honest, see, and that's the tricky thing. It's every court, every jurisdiction is so different. There are some that are way quicker than others. That does not seem very, I mean, you know, quick to me would be a month. So 4 months is kind of, it's still kind of the time frame that I would almost expect for regular probate. So that's interesting. That's interesting to see.
Yeah, and the legal fees were, I would imagine, substantially less. They were around $1,800 all in. So
Yeah.
that was obviously great.
Yeah.
But I was a little bit surprised at the time frame too.
Yeah.
Yeah.
Yeah, I know, unfortunately, that's the thing. When it comes to the courts, we're kind of at their mercy once the application is in. So the hope is there that it would be quicker, but there's no guarantee.
Yeah.
Thank you.
Great, thank you. And I see also John has raised his hand. Go ahead, John.
Hey, Daniela, thanks for putting that together in a great summary for us. It is complex. One thing I'm always concerned about is predatory relationships, and I see this really closed a big loophole for that. Is there any other areas that someone who is vulnerable could be exposed or could be at risk of a predatory relationship? So this closes that loophole. I know, excuse me, about the will being canceled at marriage. And I know for POAs and things like that, you have to be of right mind and body, or at least right mind to do that. Is there any other loopholes where someone who is vulnerable could be targeted?
I mean, there's always, so, you know, it's very possible that, you know, it could still, there's always going to be an intersection with family law as well. So, you know, there could potentially be, you know, some undue influence factors when it comes to even, you know, somebody moving in, and, you know, it doesn't necessarily, you know, it won't 100% protect. So these changes won't 100% protect, you know, from these predatory relationships necessarily. It's a big aspect because, you know, especially now, you know, with increasing wealth and intergenerational wealth, like it's going to be we're seeing greater and greater transfers of these of money and property, and potential impacts to people's estates. But yeah, I would certainly see that, you know, in the interplay with family law. So potentially with, you know, separation agreements, cohabitation agreements. You know, there's still, people are always going to find a way, I think, to try to unscrupulous people are always going to try to find a way to take advantage of vulnerable people. You know, they might, you know, as you know, you mentioned the powers of attorney. So yeah, somebody could be found capable of making a power of attorney, and they might do so and appoint somebody who doesn't necessarily have their best interest. And in that sense, you know, if they're appointed, they get control, you know, they can make some changes before that person dies, you know, and potentially affect their, you know, change bank account, make themselves join, change ownership of property. So there is, you know, there is still risk. You know, this is just one aspect. It's, you know, it hasn't, the changes haven't necessarily affected what happens before death, if that's kind of what, I don't know if I'm answering the question.
Yeah,
or if that,
yeah. No, yeah. I'm thinking of the scenario where a caregiver kind of starts moving in and taking over, but I think you've answered my question. Thank you, Daniela.
Yeah,
Great presentation.
No problem.
Great, thank you, Danielle, and thank you, John. Anybody else? Again, you can write it into the chat.
I do have a
Debbie.
couple of questions. Sorry, I'm
Oh,
not
Joanne.
on video. Hi.
Debbie, you can go after Joanne, okay? Awesome.
Yeah.
All right,
Sorry.
go ahead, Joanne.
I'll put myself on video, though I don't know what I look like, because I've only got Daniela on my screen. So 2 questions. When you were saying about separated people, I guess that's a legal separation, or what if they're just living apart and something happens?
Yeah, so legal, yeah, when we talk about separated, it means that they are, you know, the couple has, 2 married people have split, and there's no hope that they will get back together. So the intention is that maybe eventually they will get divorced. So yes, legally separated.
Okay, so if there's no paperwork in order, it's like,
so that's
you
going
know
to be,
what I mean? Yeah.
Yeah, that'll be the tricky part. So even if they don't have a separation agreement, you know, they could still be separated, and, you know, with the intention that they are no longer going to continue to live together as a husband and wife.
Okay.
So, and that's where it's going to get tricky, and how it's going to, you know, we still, because this is so new, we don't know yet how it's going to play out in the courts, because the date of separation is really, that really becomes contentious in
Right.
family law in itself. And so it will also likely become very contentious now in our estates.
So it would be a lot smoother if they actually had a separation agreement in place, signed, that sort of thing.
Yes.
Right?
Yes.
Okay.
Absolutely. Yeah.
And then second question, sorry, and this I'm asking for my mom. Her will is dated 1997. I mean, it's valid and everything. Is that okay still? Like, I mean, is there such a thing as it being too old?
No. I mean, a will, I've probated wills from 1960. So as long as there's nothing in there that, and there was no, as long as the person that's, let's say, you're appointed the executor, as long as you're sure that there's no other will floating around that she would have executed later, because a new will still revoke a previous will.
And how do you find that? Because honestly, I think there is a newer one, because I can't believe it's 1997. I mean, her and my dad moved, blah, blah, blah. My dad since passed away. But I mean, and she's of sound mind and she's adamant, no, I've never had another one done. So I'm like, okay, but can you look for one just in case she's like forgotten? Or, I mean, I'll say quote unquote care, because the will she has right now is very basic. It's, my sister and I, blah, 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 which is fine.
Okay.
But I just don't know if there's a newer one floating around, but she's very organized. So I'm thinking if she had one done at some point, she would have it. But I'm just,
Yeah, I mean, you would really have to do your best. So, if you're aware of the lawyer, so if she had the will prepared by a lawyer, first step would probably be to call the lawyer and say, hey, did she do another one? If, something happened. Just to make sure that you're doing your due diligence. Because usually if there's a will that's quite old, it's very likely that there's a new, I mean, I shouldn't say very likely, it's possible, right? That there would be a newer one. But sometimes there isn't, because they just don't get around to updating their wills, and things happen.
Okay.
Yeah.
All right. Thank you.
Yeah, no problem.
It was a great session. Thanks.
Yeah, no problem.
Thanks, Joanne. Debbie, I'll let you answer. Go ahead. And then we have some questions in the chat. So Debbie, go ahead first.
Thanks. I was wondering if there's anything you need to consider or any issues with having an executor in the United States or leaving money to an adult child who lives in the US?
Yes. So if you're appointing a non-resident executor, we typically don't, obviously, again, every family situation is different. Sometimes there really is no option to appoint someone who is resident in Ontario. So if you are in that situation where, the only person that you trust, or only people that you trust to take care of your estate once you pass away is a resident of the US, a non-resident, I should say, of a Commonwealth, so jurisdiction like the US, then the problem with that is that the court, when they're applying for probate, the court can ask them to post money as a security before they'll be able to actually get the certificate. So, and it can be up to double the amount of the estate. So what they would have to do, I mean, not very many people have, let's say we've got $1 million estate, not many people have $2 million cash that they can just give to the court. So they'll have to go and get like a surety company. So they'll have to pay premiums to an insurance company who will post that security for them and continue to pay premiums until they're able to wind up the estate. And it's also a hassle because the surety company posts it into court, and then the executor, once they're done, has to actually ask for permission from the court to remove that bond. So it kind of adds additional costs. Again, sometimes there is no other option, and it is what it is. But if we can avoid it, that's kind of where we talk with, we speak with the client and say, is there anybody here who's resident in Ontario, or at least, Canada or Commonwealth jurisdiction that would be able to act in that role.
Okay. Thank you.
Yeah, no problem.
Thank you. Okay, so we have 2 questions in the chat box here. So question 1, in a separation, what about designated beneficiaries on life insurance, RSPs, etc.? I know that these bypass the estate, but is it still triggered at the time of death?
So that's the tricky, so you'd have to make sure, because it's not part of the estate. Now this applies to revocations in the will, and I think the interplay is a little bit different because you can also designate beneficiaries in the will. So overall, I will say, if you do get separated, make sure you update those designations right away, because it may not necessarily revoke, even though we are able to designate it in the will itself. The way that it's done, it still bypasses the estate. So there's a risk that designation wouldn't necessarily be revoked. So always, any major life change like a separation, you're going to need to update the document directly with, you want to let your bank, whoever's administering the registered investment, know, update your beneficiary designations, life insurance, all that, because it may, these changes may not protect against that.
Great.
Does that make sense? Yeah.
I hope that helps you out, Michelle. Okay, so next question we have, if the couples are separated, but one has a will, that will takes precedence. Oh my, I can't speak today. Correct? The separated spouse does not have the right to revoke that will. Is there a registry of wills? And this is the second part to that. So let's answer the first portion first. So basically, if a couple is separated, one has a will and the other one doesn't, does the separated spouse does not have the right to revoke that will? Is that correct? Not correct?
Okay, so let me just see if so the will, so if one has a will and they separate, and no one can really, the only person who can revoke a will is the person making the individual who signed it, the testator. So they can, and if you separate, so I don't know, maybe I'm misunderstanding the question. So maybe
let me see. A Torres, that's who asked the question. Do you want to just unmute yourself and you can maybe clarify what you're trying to ask? Perfect.
Yes. So the question is, so a couple gets separated. After the separation, one person gets a will. Let's say that person passes away. The survivor without a will, even though there's no legal divorce, that person does not have a right to contest that will, correct?
Correct. So with the new, I should say
with the new change, they are considered divorced, period.
Exactly. They are treated the same as a divorced spouse. So they do not have, any benefit that they would have.
They don't have any spousal rights.
They don't have, right? Yeah. So that doesn't mean that they can't try, because anybody can bring a matter before the court.
Sure.
But with this new change, that's exactly what it's made for. They're going to be
perfect.
treated. Yeah.
Thank you. And then, the second part of my question was, is there like a quote unquote registry of wills? Because I've heard of people passing away and the survivors are convinced there was a will, but no one can find a trace of it. No one has any clue. Like, how do you find out?
Yeah.
Aside from searching every shoebox.
Yeah. So we don't have a formal, I should say, in Ontario, you actually can register. You can give your will to the court for safekeeping. They have a register or a registry, a deposit of wills. So we do have that. You're not required to do that, but there is an option. Now, it's not too common. Usually, as lawyers, we either keep the original will and store it for the client, or they have their own, safe at home, safekeeping at home. The other thing is there's a software company they are building a national registry of wills. Again, it's a private company. It's not regulated by the government. It's not to say that it's not good. It's just, it's not, not everyone is required to upload their will documents to this registry. It's optional, and it's only really available for the people, the lawyers that are familiar with the software that then pass that on to the client, right?
Okay, so it's not an automatic. So
no.
if you don't know who this person's lawyer is, or they haven't mentioned anything, then you're SOL if you can't find anything.
Yeah. So you have to, it does take, for some people, it takes some investigative work and, and then, at the end of the day, if nothing is found to the best of your knowledge, there's no will, then, then that's what it is. But if it, sometimes it happens where people are, a year goes by and then all of a sudden something turns up, they end up finding a random file somewhere, right? But I mean, there's no required automatic registry that will allow anybody in the province to know, okay, this person has a will. Sometimes we have to, even as lawyers, we'll put out a notice to others in our industry and say, we have a network where we'll say, hey, does anyone have knowledge of the estate of this person, or knowledgeable will, please contact us.
Okay, great. Thank you.
Yeah, no problem.
Great, thank you. So I don't have any other questions in the chat box. I'll take one more minute. If anybody wants to either put something in the chat or unmute themselves or raise their hand, they can ask Daniela a question while we have her here. Debbie. Yep, go ahead, Debbie.
What happens if a lawyer, you're dealing with a single lawyer, or a law firm ceases to exist anymore? Do they let the clients know about their will? How do you handle that?
So it depends. So are you saying if the lawyer is going to retire, for example? Yeah. So in that situation, they would have to, yes, contact the clients that they have original wills for and give them the option. Say, for example, some retiring lawyers will transfer their practice to a younger lawyer, and they'll say, let the client know, like, I can do this, I can transfer it to this lawyer, or give the original back. If it's a situation where we have a sole practitioner lawyer who unfortunately passes away, and there was no succession plan in place, in the worst case scenario, the Law Society of Ontario actually takes control of any original documents and files that the lawyer had, and then we'll deal with it and transfer it or contact the client, as best they can.
Thank you.
Okay. So, I do have one more. Go ahead.
Hi. Hello. Hi. Can you hear me?
I can hear you. Yeah.
I just have a question. My dad had passed away in January, and he appointed a lawyer as his executor.
Okay.
And he left a trust for my daughter, for his granddaughter. So it looks like she's not going to have access to that until she's 25. She's 6 years old. Is there any way I can change request the age to be changed? Because that's a long time. Like, she's 6, right? Like 25, it's like, it's a very long time. He's going to be involved in our life. And I'm just wondering, is there any way to change the age?
So it depends on what's in the will. Usually, and because every family is different, everyone's wishes, it really depends on what your father put in the instructions. In our, certain wills will put instructions where it says, yes, the age is this, but if, there is discretion to the trustee to close up the trust early, or, usually trust for minors, I'm guessing that's what, was included in your father's will. There is instructions that if the child needs anything for any, maintenance or any, like, the benefit that would otherwise benefit the child, there's often instructions that money can be paid out. If there's extracurriculars that the child would need, they just can't get their whole sum all at once, basically, to do what they like. But again, it's really limited by what's in the will. So I wouldn't really be able to tell you. I'd have to see the document, but yeah, it's really, you can't really change that unless there is discretion that's specified.
Yeah, no, not change it, but just have, I guess I'll have to point a request or something, but I was just wondering what would be deemed, like, I would just wanted examples in terms of, okay, I guess for schooling or education, things like that. But
yeah, typically we, there is instructions in the trust that would allow that, but I don't know, but if it's going to apply, to every, I wouldn't be able to say for sure, but it's not uncommon to see that.
say if I have, say if it's not instructed in the will, I would just have to talk to the lawyer then, right? Because I think I have a copy of it, but
Okay.
I need
Yeah.
to look through, I need to thoroughly look through it. But if it's not specified as per detail, the nitty gritty for what, for this, for that, I could just go to him and just present my case, right?
Yeah, I think you should be able to have a dialogue with the lawyer, and yeah, because at the end of the day, generally, I mean, again, just to comment on the general powers, an executor does have discretion. They do have general discretion to deal with the estate because they need that flexibility. But again, there's certain things that may be limited depending on what the intention was.
Okay, thank you so much.
Okay.
Great, thank you. And we'll have one last question come in. So this is the last one from Leslie. So estranged family members, when individuals do not talk to each other or have lost touch, or children of other marriages, what is the process for notifying those individuals? Is there a requirement by the executor, lawyer, etc.?
So if they're included, so if there is a will and they're not included in the will, then there really is there's no like specifically dealing with the property division aspect, there's no obligation if they're not included in the will to notify them. From a executor side, I guess maybe just out of to notify them of the passing, that might be something. Again, it depends on the situation. There's no necessarily legal requirement to do so. If there is no will, then the intestacy section, so the portion where that deals with when there is no will, and it usually divides the estate a certain way, so usually to next of kin. So we've got spouse, kids. If there's no, so it kind of goes through elimination. If there is no, it goes down the line of blood relations. And in that case, if someone is applying to administer the estate, then they would have to, deal with, they would have to notify family members that might be entitled to a share of the estate.
Great. I hope that answered your question, Leslie. I want to say a big thank you to Daniela. Thank you for taking some time and joining us today. Thank you to Kaiser Mason Ball for hosting this event as well.